Stan Taylor is Emeritus Professor of Political Science at BYU, former chair of the Department of Political Science, and founding director of the David M. Kennedy Center for International Studies. He was a member of the first staff of the Senate Select Committee on Intelligence, where he was one of two senior staffers who developed the Foreign Intelligence Surveillance Act, or FISA, in 1978. Professor Taylor retired from teaching from BYU in 2006, but has continued on as a senior fellow here at the Kennedy Center, where he is active professionally, both publishing and teaching. He's been a visiting professor at the University of Kent in Canterbury, the University of Wales in Swansea, and the University of Otago in New Zealand, where he's taught a course on U.S. intelligence and national security, and was a Fulbright Senior Lecturer in 1993. He's on the Fulbright Senior Scholar Registry. Before coming to BYU, he taught international relations at Tufts, where he was the chairman of the government department, and at Bentley College in Boston for 4 years. Professor Taylor is on the board of editors of the academic journal Intelligence and National Security and publishes frequently in intelligence journals. He wrote the chapter on treason for the Oxford Handbook of National Security Intelligence in 2009 and has a chapter in every intelligence handbook published in the last 10 years. Professor Taylor received his PhD from the Fletcher School of Law and Diplomacy. Most importantly, he says, he is father, grandfather, and great-grandfather of 35 really great people. There is no one more qualified, not only here at BYU, but that I can think of that we could have to talk about this timely topic. Today's lecture, Secrecy, Privacy, and Espionage, Snowden and the NSA. Please join us in welcoming Stan Taylor.
Without telling Corey, I changed the title of my talk. I hope that's all right, Corey. I now call it, Is the Government Spying on You? So let me start with a little bit of background. The 3 T's you need to understand about intelligence, particularly surveillance intelligence. Antiquity, there's the T in it, ubiquity, and necessity. Few activities in this world are older than intelligence gathering. As you know, it's often referred to as the world's second oldest profession. You just have to read Joshua to find that out. Ubiquity, every state that I know of, even the Maldive Islands, the smallest state in the UN, has an intelligence group that works for it. Every state does. And the necessity, in an international system where there is no superior authority, every state must look out for its own interests, hopefully under certain guidelines. States that fail to collect intelligence, I argue, have a death wish. It requires a careful balancing act to do that. I love this cartoon by Clay Bennett, Christian Science Monitor, taking a letter or two out of liberty, a little bit out of justice, one letter out of freedom, in order to get security. There's trade-offs in this business. How nations do not collect intelligence. Forget all of that. It's not how intelligence is done. As I say on the slide, you get no information from a dead person. So how do they collect intelligence? I'll just mention the CIA once. It's not the topic of our talk today. But just so you'll know, CIA and to a lesser extent the DIA and the Uniformed Services Intelligence Agencies all collect human intelligence. It's always called HUMINT. The way the CIA does it is they send their officers, case officers from their national clandestine service. They send them abroad. They live in foreign countries. They get acquainted with people who might be willing to help the United States pass some sort of information on, and that's how they do intelligence. These people that they recruit are called assets or agents, and most people are shocked when I say that CIA employees are not spies. They're case officers. Shirley, there's a seat right here. Wouldn't you like that better? We want today to talk primarily about NSA, the National Security Agency. They collect what is called SIGINT, Signals Intelligence. It goes by other names in different categories, but by and large it's referred to as Signals Intelligence. It's information, intelligence that's collected through electronic or technical means. Often through tapping into communications networks of foreign nations and other kinds as well. primarily done by NSA. A few other agencies dabble in it. NSA is the best. It is the great vacuum cleaner in the sky. You'll be shocked to learn that the largest library in the world, the U.S. Library of Congress, if you digitize everything, it contains 100 terabytes of raw data. The NSA collects that much information every 3 hours. So, if this is important, let's ask ourselves, how can they protect the sources? How delicate and fragile are these sources of information? Because that's where we're going to get to people like Mr. Snowden. Well, just for a brief historical stop, let's talk about World War I. World War II, I mean. You might remember that the Germans had invented a machine that would encrypt their communications. It was called the Enigma machine, invented by Walter Scherbius. The German scientists, by the way, calculated how long it would take for a person who received an encrypted message from the Enigma machine, how long would it take through what's called a brute force attack, that is, try every possible combination. How long would it take to decipher a message? And the German scientists estimated 900 years. Of course, because of the British at Bletchley Park and the Americans and some valuable help from Polish and even a French spy, they were doing it concurrently. By the end of the war, they were reading about 60 to 70% of all German classified communication. This was all part of the effort made to allow the United States to invade occupied France. And you know all about that. All of the intelligence that came from the Enigma machine was classified, stamped on it, ultra. That was a compartment, they call it. In the Pacific Ocean, classified information we had from Japan was classified as magic. And 3 operations, Operation Overlord, Fortitude, and Bodyguard, were all created to protect different parts of the Allied invasion. Had information from any of those been leaked out at that time, Eisenhower estimated that it would have taken an additional year and an additional, as many people who were killed on that initial D-Day, it would have doubled that to take care of that invasion. That's how important this kind of information is. The bodyguard term here came from a speech by Churchill, who said that sometimes the truth is so precious that it must be protected by a bodyguard of lies. And it's this information about which he was speaking. If we jump down to the Cold War, there's 1,000 stories. One of my favorites is the Politburo in 1971. In late 1970, the Politburo, the highest governing Russian political body, a Soviet political body, up till late 70, they had never heard or trusted mobile phones in their cars. We were using them in America many years before that. But in late 70, they decided they would put mobile phones in all of the Politburo members' cars. And they loved it. They were communicating with one another. And of course, we all know that anytime electronic communication goes out, it's a free good. And we had a satellite, geosynchronous satellite, straight above Moscow, and we were listening to all their conversations. Then in 1971, a wonderful guy, he taught the gospel doctrine class at the Chevy Chase Ward through all of this. He was a famous columnist for the Washington Post, Jack Anderson. He had a friend at the CIA who told him about this, but told him not to tell anyone. And of course, Jack Anderson published it, and all of the phones were taken out of them. We lost Chris Andrews, probably the best intelligence historian in the world right now at Cambridge. He says that was the greatest blow ever to U.S. intelligence. And you've heard stories about bin Laden and cell phones, and sometimes people say they're myths, and parts of them are, but I can tell you with some assurity that the first satellite phone he had, he used and people knew it. It wasn't a secret. Peter Bergen, who was the only American ever to interview bin Laden, he saw him using it while he was there, so everyone knew. But when the NSA got this information, they found a way to tap into that. A story in the Washington Times highlighted this It didn't reveal any secrets. Everyone knew he had a satellite phone. But when bin Laden read that story, he got rid of that satellite phone. A few years later, he got another satellite phone. It's called a Thuraya, a new kind. And people told him no one could intercept that conversation. And of course, that leaked just around 9/11, and he stopped using that. And after that, it took us 10 years to catch him because he had given up all communications except that by a courier. So these communications we're talking about, this kind of SIGINT intelligence, is very critical, very significant, and is very fragile. You can lose it at a moment's notice. So if these methods are so fragile, how does the U.S. government go about trying to protect them? Well, the primary, or the earliest, the oldest practice was to try to ban treason, outlaw treason. It's the only anti-espionage law that's contained in the Constitution itself, Article 3 of the Constitution. We copied largely the old British anti-treason law. That law had been in effect in Britain from 1315 up till today. And it was been changed a lot, but it wasn't until 1840 that they took the requirement out of it that a person convicted of treason would be drawn and quartered and their intestines pulled out and fed to birds. That was in the British law till about 1840, as I recall. So has this constitutional ban prevented treason? The answer is no. In spite of literally hundreds of treasonous or traitorous acts, only 38 people have been charged with treason in U.S. history, and only 15 have been convicted through that time. There's a list of them, and without spending any time on it, let just me highlight that the first ones occurred in 1763, the famous Whiskey Rebellion, when Western Pennsylvania tried to secede from the Union. There's 2 of them. There's a few minor ones. There's a few that come in the Civil War. This group right here was all the Civil War. But from then on, it was all World War II. And so it took a long time. Why are there so few convictions? Well, the law requires that the nation must be at war. So that helped with World War I and World War II. But the Cold War wasn't officially declared war. Now, I personally believe that the global war on terror qualifies as an officially declared war. It never used that language, but Congress authorized the president to use all means available to capture and kill the people who had attacked the World Trade Center. But not only that, a traitor must adhere to an enemy state. Well, Al-Qaeda is not a state, so that made it tough. And in fact, some of the early prosecutions that could have been made of World War II and Cold War spies were not made because they were spying for Russia, and Russia was our ally. All through World War II, Russia was our ally. They didn't qualify as an enemy state even through the Cold War. A traitor must give aid and comfort to an enemy state. And a traitor must either confess to treason or be convicted on the witness of 2 people who had witnessed the act of treason. You can see it's a rigorous standard, and it was difficult to use for other reasons. So the second approach that states used was to ban espionage. And in the Espionage Act of 1917, they defined that, and you can see what it is there. Has that been successful? Well, it didn't have the problem of defining enemies as states. But it was associated with U.S. military actions or proposed actions primarily. Have anti-espionage laws prevented espionage? The answer there is maybe. It has done some good. What the problem you have here is that a lot of people caught or accused of espionage are not ever charged. Just 2 years ago, we saw 11 Russian spies in the New York area, all caught, good evidence because of something I'm going to talk about later, but they were never put in jail. They were traded for some people that Russia had put in jail who they claimed were American spies. They were traded for them, and one of those poor 4 Russians who the Russian government claimed was an American spy, to this day says he never was a Russian spy, but he now lives in the United States anyway. He was traded. He didn't want to be traded. So there's a chart put out by an organization I belong to, showing the number of people at least identified in espionage-related activities from 1945 up to 2013. So you can see that these are the World War II running up till 1953 when the Rosenbergs were given the electric chair. Then it picked up a little bit when the Cold War became sort of official, but then it was really low, stayed low till right there, and that's the year that a particular act of Congress was passed, which I'll talk about in a minute. So why were so few prosecuted under the Anti-Espionage Act of 1917? Well, at least prior to 1970, it was too difficult to attain evidence, solid evidence that would hold in court, sure a conviction. Particularly, U.S. national security was damaged when the government followed the principles of the Title III of the Omnibus Crime Act of 1968, President Lyndon Johnson's so-called masterpiece. It has a longer title than that, but I'll just call it the Omnibus Crime Act. Because under the Crime Act, a warrant to collect information secretly, primarily signals intelligence, had to be obtained in an open court. The pretrial discovery process applied, and you lawyers can explain that, but that's when the defense and the prosecutors have to share information they have so that nothing is a surprise in the trial. So that digs a little deeper, and then the trial itself can dig even deeper into it. So the government, the United States government, was reluctant to treat espionage as a crime, at least under the Title III of the Omnibus Crime Act, for at least three reasons. One, it would verify the truthfulness or significance of the information that they had purloined. The initial reaction to a government when somebody comes up to an agent of theirs and says, I want to help you out, here's some information, the initial reaction is that it's false information. It's what they call misinformation, or what they call in the business a false flag operation. They're representing themselves as operating under a loyal flag to you, and they're not. So the minute they do that, then the truthfulness and the significance of that information is strengthened. The U.S. government must think that's pretty important. They're prosecuting someone for it. Secondly, it puts sources and methods at risk. I've mentioned that briefly, but for example, from 1942 up through 1953, the Army Security Agency first, which later became the National Security Agency, had tapped into Soviet communications, transatlantic communications. And we were reading all of their encrypted data, their communications. Now, they were encrypted, and all their assets in the United States, they were referred to in code by code words, but still we were getting a lot of information from it. We learned from that, by the way, that Julius and Ethel Rosenberg were truly Soviet spies. There's been a whole mythology to develop about that. They were Soviet spies. We learned that, but we couldn't use that evidence in their trial because it would have demonstrated to the Soviets that we were reading that traffic. And third, the entire process, the discovery partial and the trial itself and so on, might reveal more to the enemy than had been revealed to them by a spy. So how to solve this dilemma? Well, the dilemma, how can requests for warrants under the Omnibus Crime Act be issued when the warrant procedure, the trials, the discovery, are detrimental or even hazardous to U.S. national security? And if you go back to that chart, I don't think I've got it again, but I used to. If you go back to it, you'll see that that's why so few trials, accusations, arrests were made under this act. So enter now the Foreign Intelligence Surveillance Act of 1978. I won't go through the origins. I just want to focus primarily on number 3, the church Committee hearings with all the volumes they published that revealed years of executive branch misuse of signals intelligence. And then the Watergate crisis, which again revealed in that case the Nixon White House using surveillance and so on without government warrants and breaking into places and collecting this information, and it brought down the Nixon presidency. So it eventually became clear that even national security practices needed judicial review because of the abuses that we had witnessed by these episodes here. So the Congress created the Foreign Intelligence Surveillance Act. That act created a FISA court and a FISA review court with 7 judges, all drawn from district courts around the United States. I mean, these are not hacks for the government. These are regular district judges who rotate and serve time on this 7-man court, which was increased to 11, by the way, under the U.S. Patriot Act. The FISA court, the government would go to it, the Department of Justice would take an application to it, and if it were in a criminal court, it would be called a warrant. We didn't use that term when we created this law for confusion. So it's just often referred to as a warrant-like paper, or sometimes I'll call it a warrant. It's just easier. But it's technically not a warrant, but it comes about through the same mechanism. This warrant paper would authorize electronic surveillance on American citizens, at least if the court were convinced that they had reasonable cause to believe that they were indeed working for a foreign power. The FBI would serve those, and it solved the problem. I hate to say it, but it solved the problem by creating a secret court, the thing that's been anathema in American history from our British colonial experience for 250 years. It's been anathema. But this is quite a different court, and I will defend it to anyone who wants to talk to me about it. Significance of FISA ended over 200 years of executive department abuse of government surveillance practices. The FISA court was the key. People, even the ACLU, agreed with the original FISA court provision. Their argument was that a judicial review, even by a secret court, is better than no review at all. So the government, with a permission, with this FISA warrant, can tap into the communications those who are trying to steal national secrets. And just a brief note of personal involvement. As Corey said, I was deeply involved in this particular process. I was on the Senate Intelligence Committee. I was a senior staff member there, and worked for probably a year. The bill itself, or the idea itself, came out of Edward Kennedy, Senator Kennedy's Judiciary Committee. But until the Senate created an intelligence committee, all of whom were briefed on and cleared for national security purposes, they could not brief Congress on what they were doing. But now they could. And so it was a pleasure to me to work for off and on for over a year on the FISA Act. And I brought some of the documents that came out of that, just if any of you are curious after. Now, there have been later changes to FISA. Some I like, frankly, some I don't like. Physical searches were added in 1994. We tried to get physical searches in the original act, but the ACLU wouldn't allow it. Physical searches are what allow the government body, primarily the FBI, to look at someone's physical property. Garbage, that's how they got Robert Hansen. They knew he was a spy, but how to convince a court? They had to get evidence. They got it by going through his garbage. They got a permission to do that from the FISA court, and many others. In 1999, they added pen registers and trap and trace devices. That's obscure words, but a pen register registers every phone number that is called from a specific telephone. And criminal enforcement agencies have been able to do that for 100 years. But the government couldn't do it without a warrant. And the criminal agencies had to get a warrant too, of course. They expanded the definition of a foreign power in 1999, which, as I say, was necessary with the rise of terrorism. They liberalized the application process, and then the overwhelming change to FISA came with the USA Patriot Act. Among any other provisions, two are worth talking about. One was roving wiretaps. Legally, a wiretap is issued against a specific phone number and a specific person. And nowadays, you can call on a cell phone, throw it away, and get another cell phone. Well, the FBI had to go to the FISA court and get another warrant for that. They added this roving provision. And also, they added the use of the national security letters, and I'll talk about that more in a minute. On most of the provisions of the Patriot Act, some of you remember that, sunset dates were set, meaning a date was set when they would expire. But as I say, on them, the sun has never set. Let me just say a word about a national security letter. It's obtained through an administrative process, does not involve any judicial review. That is, the president could call somebody in the Justice Department, say, we need to get some information on so-and-so, get a national security letter for me and I'll sign it. And that was it. There was no judicial review at all. Requires the entity served with this national letter to reveal information to the FBI. This is what got us in so much trouble for a few years when we were serving. FBI would go overboard because even regional officers could authorize a national security letter, and they would take them to libraries. And they would require a library to reveal all the books that a certain person had checked out, thinking that if they checked out a book on bomb making, it might be used as evidence against them and other kinds of things too. But these got way out of hand, and part of the national security letter is a gag order that would forbid the librarian or anyone to whom it was served from telling anyone about it. I had a particular distaste for the national security letters. What went wrong? Well, President Bush got impatient with the global war on terror. GWAT, I hate that word. I'm glad President Obama has changed that. We don't use that term anymore. He searched for a way to get around the FISA Act requirements, and he found three ways. One, to use terrorism as a threat to expand FISA practices. Some of that was needed. Two, to ignore FISA and issue executive branch orders, all he claimed under the authority of the famous authorization for the use of military force, the declaration of war that Congress passed right in 3 days after 9/11. And then he expanded the use of these national security letters. These three practices sparked all the criticism against against government surveillance that we thought we'd gotten rid of with the FISA Act. On top of this now increased concern over government surveillance, enter these two critics, Private Bradley Manning and Edward Snowden. There's what Manning leaked. 250,000 U.S. diplomatic cables. These were not highly classified, but they were highly embarrassing. Ambassadors talked quite candidly about foreign leaders in these cables, and this was all revealed through those letters, diplomatic cables. 500,000 Army reports were released by Bradley Manning. They came to be called the Iraq War and the Afghanistan War logs. And as you know, just last July, he was sentenced to 35 years in prison. Snowden leaked, and Snowden, you know, is now in Russia under a temporary asylum. Some say Putin gave him a year. We'll see how long it lasts, but I'm sure we'll get Snowden back someday. Putin doesn't like him either. He leaked interception of a lot of U.S. and European telephone, sometimes they call it telephony, metadata. I'll talk about that in a minute. And the existence of some NSA programs that we're seeing things about that we have always been highly classified. The Prism, XKeyscore, and Tempora internet surveillance. Daniel Ellsberg of Pentagon Papers fame said it was the worst leak in U.S. history. just what's the metadata? Now we're getting to the heart of this matter. What is this metadata we talk about? Well, that's what it is. Those 7 items. Items 4, 5, and 6 are technical. I could tell a little bit about them if we had time, but I'll skip over them. The main thing is the originating and terminating phone numbers, time and duration of a call, and the routing information of the cell phone itself, and even email. Notice, this is the metadata that Snowden revealed the U.S. government is collecting. And if I took a survey of, certainly not you because you have good instructors here, but if I took a survey of the American public and said, do you think the U.S. government is reading my email and tapping into my personal phone mail, they'd probably say yes, they are. In fact, the government can do all of this, 1 through 7, and it's still not allowed to listen to any recorded information. They have to get a separate warrant for that. And in fact, to even get the information, they get this information from the carriers, Google, Microsoft, Yahoo, and so on. 9 major U.S. information technology carriers provide this information to them because we've served them a FISA warrant. And that warrant has to be renewed every 90 days. I mean, the government is very concerned about not violating privacy to the greatest extent that they can. Most people don't know that. What are these 3 programs? I don't know if we want to get are you interested in any of those? Prism is primarily, I made some notes on it that'll help me. Prism is primarily a data mining program. Google and so on, all these companies, when they're served this letter, they have to provide records that they have of even conversations in the past. They have to provide it to NSA or the FBI. Prism is also of some interest because it's part of the only intelligence treaty in world history. There isn't a secret intelligence treaty, the exact contents of which are still never been released, between the United States, Great Britain, Canada, New Zealand, and Australia. And PRISM was a program that all of these countries were using to sort of mine existing data. The XKeyscore was a way to identify foreign nationals. It's a very tricky way, and it's a sophisticated program that they use to do it, because an email doesn't, or a recorded conversation doesn't tell you whether you're listening to an American or a foreign person. And we don't allow the same protections to foreign persons that we do to American citizens. But XKeyscore is that. Here's the problem. You have to locate a small needle in a gigantic haystack. And to do that, you have to first locate the haystack. So the information that Google and these companies give them is a gigantic haystack. I mean, it is huge. And then once you've located the haystack, you have to search for the needle in it. So it's a very complicated process. What can they not do under this? NSA cannot listen to any conversation unless they get a warrant, an additional warrant. They cannot keep any unnecessary information. When we drafted the FISA law, we put in what was called a minimization law, part of the law. And any information that was collected had to be immediately minimized, meaning put into a place where it was very hard to get to for 5 years and then be destroyed. So they have to minimize anything that is not relevant to national security matters. These are laws they have to live by. They can't read any emails unless they get an additional warrant that allows them to do that. They had to get a warrant to get access to those. They can't read it without an additional warrant. You might be surprised to know that last year, 100 billion emails were sent each day of the year. So that's a big data set to get through. Big data set. I know because I get maybe 10% of those. They cannot listen to or view any communications of any kind that are solely domestic. Now I say if they can help it, because sometimes, you know, every major international communications carrier is based in the United States. So all of this stuff eventually comes to the United States and it gets commingled. But if it's identified as purely domestic, it has to be minimized immediately. And they do not operate under a rule-free environment. They have very strict rules, obviously not strict enough, but they have very strict rules. Last year, 2012, this is NSA reporting that their supervisors identified 2,776 privacy violations. You can see what a small error rate that is out of all of those billions of communications, but they're very serious about it. Just yesterday, the NSA released a statement that they're going now to require 2 people to be sitting at any computer that carries any of this information. That's going to raise the cost a lot, but it might help. It might help. Job openings, yes, Tom. NSA, frankly, has neither the time nor the desire to listen to you calling your Aunt Alice. Why would they want to listen to that? I might add, if Tom Draper doesn't mind me saying, that he has a son who's a very senior mathematician, mathematician with NSA. And he's part of this group that's invented these computer programs that will do all the stuff that they're allowed to do. It's been very wonderful. So, is Snowden a whistleblower or a traitor? Well, let's just quickly review the whistleblower laws. Has to be a violation of any law, rule, or regulation, a gross mismanagement, gross waste of funds. The only successful whistleblower action against NSA was by an NSA employee who said they were wasting money, and they won on that one. And I think that's great. That's what whistleblowing provisions are meant to do. An abuse of authority or a substantial and specific danger to public health or public safety. And this sign hangs in every government office. It's supposed to. Well, let me give 3 quotations from Snowden, and then we'll narrow down to whether he's a traitor or a patriot. You can read those, I guess. I don't want to live in a world where everything that I say, everything I do, everyone I talk to, every expression of creativity or love or friendship is recorded. Nicely worded to get people angry, isn't it? Who wants expressions of love or friendship recorded, you know? I carefully evaluated every single document I disclosed to ensure that each was legitimately in the public interest. The government has granted itself power that it is not entitled to. There is no public oversight. Well, is he correct on those 3 assertions? Everything I say is recorded. Probably many of Snowden's conversations may have been recorded, but I can assure you none of them were listened to until it was found out that he had stolen property. Then he's a legitimate target, but they had to get a separate FISA warrant for that. Every document, 100 billion emails, he went through every one of those. And why is a document that makes it more difficult to identify terrorists, why is that in the public interest? I fail to understand that. There is no public oversight. I take offense at that. I was part of that oversight. This was approved, NSA activities were approved by 3 presidents, Clinton, Bush, and Obama, both houses of Congress, 2 committees of both houses now, so 4 committees of Congress have clearances to get briefed on all of these kinds of things. Others don't, rightly so. And by the way, those briefings are done every 90 days and extensive reviews annually. I've got one of the early annual reviews up here. It's survived 2 circuit court challenges. 1 circuit court in California just recently has challenged a small part of this. It'll be interesting to see how that turns out. It has Department of Justice approval. What about public opinion? Well, you might be interested because in spite of all this, there's 1, 2, 3 Pew Foundation surveys. They're a very reputable survey. One in 2006, which is more important, investigating terrorism versus privacy? 65% of the Americans said investigating terrorism. Went up to 68 in 2010. In June of 1913, this is when Snowden first revealed his information, it still had 62% of the American public. And then July, almost a month after, and this was not a Pew poll, but the question was the same, it dropped down to 58%. There's another one. 54% said it's acceptable to do this as long as you're investigating terrorism. 50% to 44% approved internet data even. So these have public interest. Now, has what he has done caused any harm to U.S. collection? Here's a wonderful quote by Matt Olson, who's director of the National Counterterrorism Center. He says, "We've already seen in response to the Snowden leak, Al-Qaeda," by that he means Al-Qaeda Core or Al-Qaeda Center, sometimes called AQC. That's the remnant of bin Laden's group. He said, "We've seen Al-Qaeda Central, Al-Qaeda in the Maghreb, Al-Qaeda in the Arabian Peninsula, and Al-Qaeda in Iraq, seeking to change their tactics, looking to see what they can learn from what is in the press, and seek to change how they communicate with one another." So here we are. What do you think of Snowden? Is he a whistleblower? Is he a malcontent? Patriot? A Nobel Peace Prize candidate? There's a group in Britain that's pushing his name for a Nobel Peace Prize. Deceiving leaker? Thieving defector? I'm getting all these from the newspapers. EU Human Rights Prize. He's shortlisted right now for the annual EU, European Union Human Rights Prize. He's also been mentioned for this Russian Sakharov Prize, which would be too fun to talk about for a while, but we can't do that. Or an oath breaker. I like that one. Treason, by the way, is poorly understood, the significance of it. I published an article in the Oxford Handbook on Intelligence about it, and Kennedy Center was kind enough to make 5 or 6 copies of it. If any of you want a copy, you'd be welcome to take one after. And also, for the people taking the class, Corey Drew tells me it's now online. So, okay, so here's Snowden talking to Putin. And not only that, he says, Obama spies on journalists. And what does Putin say? I like this one. "I don't mind giving up the appearance of privacy to live with the illusion of safety." And this is a Clay Bennett cartoon again. Here's your privacy, your own private home, and they're taking the boards down from it to make security bigger around it, you see. So, is the government spying on you, do you think? I can tell you with absolute certainty, probably not. I would be very doubtful. All right, thank you, Jim. I can tell you, I don't think so. That's a better way to say it. I may be wrong, but I don't think so. Unless you've got friends in Yemen that you've been emailing innocently. If you have been doing that, they've gotten those emails. Have they read them? Probably not. Probably not. That would be read. They'd have to convince the FISA court they've got evidence to believe that you're supporting terrorism to get permission to read them. So probably not. So in closing, and we'll take a few questions, let me just say that I think people at NSA, these government employees, are some of the finest people I've ever met. I wandered the halls of the NSA for several years when I worked for the Senate. And they're honest. Sure, there's occasional defectors that come out and so on, but for all the people there, they're hardworking. They make enormous efforts not to invade your privacy, enormous efforts. But they also are required by law to try to protect our national security. So that's my take on Snowden and NSA surveillance, and I'll take any questions that you have. Thank you.
Got it. Raise your hand. We'll bring the microphone to you. Tell us your name and what you're studying, and then you can ask a few questions. I know some of you will have to go to class.
They ask you to use the microphone because this is recorded and shown to other classes, and they want you to be able to hear your questions.
Hi, I'm Jacob Bills. I'm studying international relations. What do you think about the role of contractors within the intelligence community?
I'll start by saying I think the use of contractors in the whole federal government has been a terrible insult to government employees. They've done it to try to make the public think that they're not spending as much money as they are, but in all honesty, the contractors charge more than the government workers. I'm particularly concerned about it when they're doing it in areas that require national security clearances. very cautious about that.
Hi, my name is Rebecca Crandall, and I'm an open major here at BYU. I was wondering, you keep on saying about warrants and everything, but how often are they rejected for warrants? Is that something
Well,
that we need to be worried about?
Yeah, some of the ACLU people say this is not right because only 4 times in its history has the FISA court denied a warrant application. But I've seen statistics for judges and warrant applications under Title III, and most of those are given too. That's because people preparing them know they've got to go before judicial review. They're very careful about doing it, and so on. So, does that answer your question at all? Ask me a follow-up.
Why can't we see the warrants?
Oh, okay. We can't see the warrants because information contained in the warrant would violate those 3 principles I mentioned earlier. That is, it would allow an enemy, a terrorist group or a state, a hostile state, to find out that we're looking into something. It would verify the truthfulness of it and would damage sources and methods. That's why we don't see them. Some of you have another class you need to get to. Feel free to leave as quietly as you can. We can go on for another 8 or 9 minutes. Is that right, Corey?
I'm Dallin McKinnon, studying international relations. I'm just wondering if you think people like Bradley Manning and Edward Snowden inspire other government workers that might have the same concerns to defect and do the same thing, and if so, what does the government have to do to prevent that?
Boy, that's a good question, Don. I think there's always a little bit to a copycat effect, as there is in crime. There's a little bit of a copycat effect. So I think the government, particularly NSA and those that deal with highly classified information, they've got to make sure that contractors are brought in under their purview. They've just got to be extra cautious that this 2-people rule is going to help if that gets funded. I think that's the only thing they can do, because on the other hand, we didn't get a lot of copycat after the Pentagon Papers. I don't recall any. I don't know if Snowden was a copycat of Manning or not. That was 3 years earlier. I wish we had time and we weren't on microphone to talk about the personal characteristics of these 2 leakers, because it raises questions quite obviously. Good question, Don. Thanks.
Andrew Jensen, political science major. Do you think that Edward Snowden is a traitor?
Yes.
If so, do you think that he should be put in jail?
Yes. An easy one. Yes, I do.
My name is Holly, and I'm a political science major. My question is regarding how effective these strategies really are in preventing
Good question.
terrorist attacks
Thank
or
you.
things of that sort. I mean, because we have the Boston bombers, for instance.
Right. Good question. And what did we say about the Boston bomber episode? We said, why didn't we have this information recorded? Well, because the public has been so concerned about it. We've got so many guards against it. They actually ultimately did find one little bit of information that would have helped had they known in advance, obviously. But you might be interested to know that General Keith Alexander, the director of NCA, has said that I'm using his words now, over the last few years, 50 terrorist incidents have been prevented by this kind of surveillance, 10 of which were in the United States. One I know of was a group of terrorists were going to bomb a newspaper office in Copenhagen, Denmark. We notified the Copenhagen government about this. They were able to prevent that. So that's pretty good. If you go back longer, there's been some people have told me that 300 terrorist incidents people have been arrested with legal government evidence. I don't know how many of those were specifically NSA, but 300 terrorists, they've told me, have been arrested by government surveillance. So I would guess it's been fairly effective. Is it going to stop every terrorist? Absolutely not. Because anytime something like this is leaked, then they dig deeper to find ways to get around it.
My name is Andy Mickelson. I'm an ancient Near Eastern Studies major. I'm just kind of interested in your perspective. We've talked a lot about kind of the domestic kind of backlash against this, but in terms of kind of internationally, I know, for example, the president of Brazil, and in Brazil this is a huge issue with them mining that sort of data. Is that something that was a violation of kind of NSA's protocol, or is that
no,
just...
it's not a violation at all. You know, this, you've seen this, and if you haven't, you will when you get older. The minute something like this happens, about 27 senators denounced it. 20 of them were on the committees where they've been briefed about it, not every 90 days for over 2, 3, or 4 years. Why do they denounce it? Well, because they put their finger to the wind and see which way the wind is blowing in their constituency, or they think it's blowing. Heads of state immediately announced it. Francois Hollande in Holland denounced it. The Brazilian government has denounced it. They haven't done yet, but the New Zealand government will denounce it. I know. They all knew about it. In fact, Germany, France is one of the biggest users of the metadata that we collect. So they denounce it. It's a political thing to do. That's the only way I can explain it. And now they'll pay a price for it, I'm afraid.
I'm Warren Frasier. I'm an international relations student. Actually, sort of building off the idea of France using the metadata we gather, are there any similar systems in place regarding how we share the information we get with other countries?
Yeah. As I mentioned before, the Yakuza Treaty, the only secret intelligence treaty that's still in existence. All of signals intelligence data, the Yakuza Treaty treats only signals intelligence, but all signals intelligence is shared by those 5 nations: Great Britain, United States, Canada, Australia, New Zealand. Other data is shared to countries on a treaty arrangement on an individual basis. Germany, we have a treaty with them that covers this thing. I don't know if we had a treaty with France or not. Does anyone know that? I've not been able to discover that. These are personal agreements that they like to keep quiet. So I don't know. I don't know about the Brazil episode. I don't know whether we have some agreement with them or not. But these things people will always say, no, I never heard of that. Just like the raid we did yesterday to bring in Answa al-Libi, the terrorist who did all the surveillance for Al-Qaeda for the 1993 embassy bombings in Africa. Killed 224 people, 220 Americans. We sent a raiding team into Tripoli in Libya and snatched him and pulled him out. Had already been indicted through FISA actions in a southern New York district court. And now the government of Libya is saying, we did not agree to that. Well, 2 U.S. authorities have said, yes, they did. They just don't want to admit it to their own people. That helped.
Hi, I'm Eric Lazalde. I'm a computer science major. And you talked about these oversight committees that kind of look out for our interests because we can't really know all the programs that are going on. Do they have the power to tell these organizations to discontinue practices or programs?
Oh, absolutely.
And how often do they do that?
I couldn't tell you how often. I can do say that up till 1985, when I was still affiliated with the Senate Intelligence Committee, I would see that happen maybe once or twice a year. In the early years, even in 78, 79, 80, even a little more than that. They can do that. They've done it already. They've done it right now. Asked the NSA to stop doing things to which they had earlier agreed because the political climate has changed. Well, time is up. Thank you all. You've been wonderful. I appreciate it. Thanks. If any of you want this chapter on treason, it's here. Tom, I'm glad you could come.